back to the Litigators Lounge. Joining me in the lounge today is Niall McMillan. Niall, welcome back to the lounge. How are you doing?
Good, Anders. How are you?
Very well, very well. Just a brief intro. The Litigators Lounge is devoted to the intricate world of commercial litigation with Offit Kurman's commercial litigators. Niall, in today's commercial real estate market, there's been a lot of changes, a lot of turbulence in that market. What are some steps if you're a commercial landlord or a property manager that you can take to protect yourself or your client?
Yeah, exactly. It's been turbulent out here. So a lot of people are wondering, what do I do if my tenant isn't paying or if they do in the event that they don't pay? The number one thing I would say to do is that in every lease, if it's worth its weight, it's going to have a notice provision in there. And that notice provision is going to control how you're going to send what's called a notice of default or a notice to vacate, depending on your lease. And what that basically says is that it's going to tell the tenant, hey, you haven't paid X amount, you owe this, and I reserve the right to evict you and to pursue all amounts due knowing under the lease. And what that does, that triggers the process. So you're going to have to send that before you can do eviction proceedings. Now, a lot of landlords, they want a tenant in the space. And also sometimes their personal relationships with the tenants, they know other business is doing. They may want to give them a break. That's fine to pursue negotiations and settlement on there. However, I would recommend usually is that you do go ahead and file those eviction proceedings because eviction process is a long one. I speak specifically to DC. That can take a good amount of time and even 6 months or more, oftentimes for you to actually get that ability to evict them. During that time, while that's proceeding, you can go ahead and do those negotiations, those settlement agreements, try to reach that resolution. However, you are reserving your place in line to be able to get your tenant evicted so you can replace them with someone else who's going to pay the rent.
What if you're a landlord and you've got a new tenant lined up to maybe come into the space and the old tenant's not paying the lease? Can the landlord or the property manager just go in there, change the locks and turn the space over to that new tenant?
No. And so that's what we call self-help. That's why you have to go through the eviction proceeding because it's going to have to be the sheriff or some other officer that's going to have to do the actual eviction proceeding. Please don't do that because you get yourself in a lot of trouble. That brings up a good case of what a resolution for that usually looks like. So the tenant's in there and they're not paying. Oftentimes they don't want to rack up that bill. What you can do if you have someone else to take over the space right away, you can get what's called a surrender of possession, a release from the current tenant. That doesn't mean that they don't owe the money that they owed already. However, they're going to give you back possession. You don't have to evict them and you could put someone else in there. Then you can go ahead and pursue them for a breach of contract claim for the amounts that they owe under the lease.
And all the while that that's going on, you've got a new tenant in there, hopefully a good tenant taking care of the space and paying on it. And you can still pursue those remedies against the prior tenant if they still have not paid.
Exactly. That's the best case scenario for everyone.
Anything else that the landlords or property managers should take in mind in this market when they're looking at their leases and whether they need to renegotiate them or think about enforcing?
Well, a lot of times people have a personal guarantor on their leases, and that's an important step, especially since a lot of times someone's setting up an LLC to run their business. They may be starting out, but the business doesn't have a lot of assets in it. So when that happens, it's a good idea to have a personal guarantor who's usually the actual business owner. So there are assets out there that you can reach if the tenant doesn't pay their rent. That's a good one. And also, I would say too that DC especially, they're picking up enforcement on cannabis dispensaries, etc., who aren't licensed, and they're enforcing those against the tenant and the landlord. That brings up a good scenario where you should make sure in your lease that you can recover your attorney's fees for any conduct that is caused by the tenant that you end up getting attorney's fees for.
That's a great point, Niall. I actually have a case in which a commercial landlord did not have a personal guarantee. And lo and behold, the entity went out of business or is starting to wrap up its operations. So it's leaving the landlord in a tough spot. That's a great tip. Thank you.
Of course.
Just a reminder, Offit Kurman, it's a full-service law firm. We have offices and litigators from coast to coast providing litigation services ranging from employment, financial services, business litigation, construction, government contracts, landlord-tenant. So please reach out to Niall or myself if you have a commercial litigation or a commercial landlord-tenant matter that requires attention. Thank you.